Good to see you finally.
Bwana Evans, nice to see you too.
Karibu.
Asante, I can see our president from Tanzania, Dr.
Yes.
Hosea.
Yes.
Karibu sana, Doctor. Tunawangoja wengine. We wanted to do a test run, but we don't have all of us on board.
Thank you so much, sir.
So let's just give it a few minutes, then we will go live.
But my audio is clear, yeah?
Your audio is very good, Bwana Evans. Hebu weka nani tukuone video.
Ngoja kidogo tu.
Because being moderator, we have to see you every 5 minutes.
You have seen the video is okay, yeah?
Perfect. You're looking perfect.
Man, it's called an academic look. I'm not in a suit and tie. I'm doing lots of reading from elsewhere. But then you're good to see you. Let's wait for these others, huh?
Please, if you can remind them.
CJ, who are you contacting?
Dr. Bosire.
Okay, let's look for him.
Doctor, you're welcome.
Thank you, sir. Thank you so much.
Let me put on my video. and
Nice
let me report that.
Nice to see you, Mr. President.
You too. Let me report that I'm in Arusha.
Okay.
On a courtesy call and visit.
Very good.
Yeah, we shall be able to chat more later on. I'll give you a call in the evening.
Thank you, Mr. President.
All right. Thank you. Good to have you on board.
Thank you for inviting me.
All right, you're welcome.
Mr. President, good afternoon.
Oh, good afternoon. Evans.
Yes, sir.
How are you doing?
Fine, thank you, sir.
How is Nairobi?
Bloody cold. It's too cold.
Oh, even here in Arusha, it's cold. It's so cold.
It's crazy, crazy cold.
It should get better.
We hope so.
Perhaps maybe to cool your temperatures, to cool the political temperatures.
Yeah, it's always heated over here. It will never cool.
Maybe that's the message. We're still waiting.
So we are live on Wakili TV, Mr. President. Wakili TV is the YouTube channel of the Tanganyika Law Society.
Yes. Mr. President, I wish you had been in office last year. Now that you've gotten us to Wakili TV, I wish you had been in office last year. We've been doing several webinars.
Thank you so much. You're welcome, and we look forward for more program of this nature.
And we are going to come and visit and pay courtesy call to you and the council.
Thank you so much. Most welcome.
Thank you. David, who are we waiting for?
We are waiting for the Chief Justice Emeritus, Justice Maraga. Dr. Bosire is supposed to allow him in. Let me just confirm with him. And a few of our panelists. Then we are going to go live in 2 or 3 minutes.
Yeah, the president of the Commonwealth Association, is he?
He said he's going to be on. He said he will bring his greetings from the Commonwealth and also a message of support to ELS and EAC as we look at issues of independence of the judiciary.
Okay, good.
Good afternoon, everyone, and welcome to this Rule of Law webinar of the East Africa Law Society that is going to look at independence of the judiciary in the region. We are going to kick off officially in about 4 or 5 minutes as we wait for more members to join. So we ask for your patience as we get more people joining. I can see more of our participants are joining in. We're already at almost 100.
Dr. Deche, karibu. David, can Dr. Deche hear us?
Yes, I can.
Recording in progress.
Hi, Conrad. Hello? Hello?
Hello, my lord. We can hear you, and welcome to this Rule of Law webinar. Our moderator will kick off the session in a minute at 5 minutes past 2.
Yeah, okay. Okay.
Mr. Evans Ogada, we are ready to go.
Good afternoon, ladies and gentlemen. Welcome to one of our monthly webinars from the East African Law Society. And this thematic series of webinars intends to keep us alive to the pertinent issues grounded in the principles of the East African community. Today we have an eminent panel with us that is supposed to be delving into the question of judicial independence and the concerns thereto around the region. But before we embark on the webinar, allow me to invite my president, the president of the East African Law Society, to kick us off. Mr. President, welcome.
Thank you so much, Evans, and welcome to all our panelists and all those who are joining us online. Special welcome to Honorable Justice David Maraga, Chief Justice Emeritus of the Republic of Kenya, Mr. Brian Spears, President of the Commonwealth Lawyers Association, Dr. Edward Hosea, President of Tanganyika Law Society, Dr. Daniel Ruhweza, Dr. Mercy Mwara Deche, Mr. Waikwa Wanyoike, and our moderator, Mr. Evans Odaga. Ladies and gentlemen, it's my honor and privilege to welcome you all to another East Africa Law Society Rule of Law Series webinar. Today's session, we intend to analyze the state of judicial independence within East Africa and whether the partner states of the East African community are making progress or regressing. Judicial independence in East Africa appears to be under attack and threat in more ways than one. We are observing continued executive interference with appointment processes, chronic underfunding of the judiciary, deliberate refusal to obey court orders, outright intimidation, etc. This state of affairs is worrying, and as East Africa Law Society, one of our core mandates is to promote the rule of law and good governance within the region. An independent judiciary is indispensable to democracy and the rule of law, and it is the crown jewel of a successful system of government. We must work towards it and guard it watchfully. As a regional bar, we shall continue to defend the independence of the judiciary, for we are the gatekeepers of the judiciary, which is then the gatekeeper of the Constitution and the rule of law. As agents involved in the dispensation of justice, our duty to remain true to constitutional ideals and to remain steadfast in pursuit of truth and justice is onerous, but we must fight on relentlessly. In today's discussion, we are honored to receive a keynote address from Honorable Justice David Maraga, who is the Chief Justice Emeritus of the Republic of Kenya. I thank you all for taking the time to join us, and I'm grateful to our panelists for taking the time off their demanding schedules to share their views and advice with us all today. Thank you all, and I hope you enjoy the discussion. Asanteni sana.
Thank you very much, Mr. President. Always an honor to have you on board. Thank you very much, sir, for your support and commitment to the rule of law. Today's panel is a panel that rather needs no introduction. But for purposes of formality, we will introduce our panelists to the wider audience that is with us today and watching. First in the list is a gentleman, a distinguished servant, a man who has walked the talk and stood to be counted when the rule of law, when commitment to judicial independence needed to have been done. And this is no other than my former Chief Justice, the former Chief Justice of the Republic of Kenya, the Honorable D.K. Maraga. By way of introduction, Chief Justice Maraga was the 14th Chief Justice of the Republic of Kenya and the second President of the Supreme Court, rather. Chief Justice Maraga is perhaps remembered for two very important quotes. And these quotes are, "The greatness of any nation lies in its fidelity to the Constitution and the adherence to the rule of law, and above all, respect to God." The second most important quote from Chief Justice Emeritus is, "I am sure you have seen the drums of political wars being beaten already. My colleagues, if you waver and do the wrong thing, and this country descends into chaos, God will never forgive you. Do the right thing." Amidst demeaning utterance, the path of honesty, and spoke the truth to power. Chief Justice, it's my singular honor to welcome you to this webinar. Thank you very much, sir.
Thank you very much, Mr. Ogola. You can hear me?
We can hear you, Mr. Ogada, Chief Justice.
Yeah, Ogada, sorry.
Thank
yes,
you,
Mr.
sir.
Ogada, thank you very much. Mr. President of the East African Law Society.
Thank
I hope
you
you
very
don't
much.
mind the way I'm dressed. I was told that. Sorry?
You're welcome, sir. Please continue.
Yes. Mr. President of the East African Law Society, all protocols observed. I hope you don't mind the way I'm dressed. I was told that a retired CJ should not be donning suits. He should appear in the way he appears in the village.
Thank you very much, sir.
Thank you.
We next have the president of the Commonwealth Lawyers Association. This is Mr. Brian Spears. By way of introduction, Mr. Spears is a solicitor in Belfast, Northern Ireland, and has previously served as the president of the Law Society of Northern Ireland. He practices as a solicitor in Northern Ireland, where he is the managing partner of CMG Cunningham Dickey Solicitors. Welcome, Mr. President. I hope I got the citation right. President Spears.
Indeed, moderator. It's great to be here and to bring a greeting from the Commonwealth lawyers and to be back in Kenya again, albeit virtually. So thank you for inviting me, and I see many friends present in this webinar, and it's a great honor to participate. And I'm looking forward to what the Honorable Judge Maraga has got to say, along with the contributions from all the other panelists. Thank you for inviting me.
Thank you, President Spears. Next, we have Dr. Edward Hosea. Dr. Edward Hosea is the president of the Tanganyika Law Society and a practicing advocate in Tanzania. He is a former Director General of the Prevention and Combating Corruption Bureau, PCCB, as well as the former chair of the African Union Advisory Board on Corruption. Basically, President Hosea is a man who has steeped himself in matters fight against corruption. Dr. Hosea, welcome. Karibu ndugu.
Asante sana. Thank you so much, Mr. Moderator, for inviting me, and I thank the President of East Africa Law Society for this invitation, and I'm glad to see the former Chief Justice of Kenya, Honorable Justice Maraga, and the President of Commonwealth Lawyers Association and others. I'm so grateful and humbled to be part of this discussion, and I look forward to the enrichment and the cross-fertilization of ideas. Thank you so much.
Asante sana ndugu, Dr. Hosea. Next, we have Dr. Mercy Mwara Deche. Dr. Deche is a lecturer at the University of Nairobi, a practicing advocate, as well as the immediate former vice chair of the Kenya Judicial Service Commission. She's an accomplished scholar in her own rights and a publisher, an author rather, of so many publications, scholarly publications. Dr. Deche, welcome.
Thank you very much, Evans. It's my pleasure to be here with all the panelists and especially my fellow retiree, the Chief Justice Emeritus. I look forward to a fruitful engagement.
Thank you, Dr. Deche. Next in line, we have a respectable man, we have Mr. Waiko Wanyoike. Mr. Waiko Wanyoike is the litigation director at Open Society Justice Initiative based in London. Before joining Open Society, Mr. Wanyoike was the executive director at Katiba Institute in Nairobi for 8 years. He's an advocate of the Kenyan Bar, as well as a solicitor and barrister with the Law Society of Upper Canada. Mr. Wanyoike holds a Juris Doctor degree from Queen's University in Canada, and is an alumnus of the Kenyatta University in Kenya, as well as the York University in Canada. He has a formidable teaching experience, notably having taught refugee and immigration law at Osgood Hall School at York University in Canada. Mr. Wanyoike has been formidable and committed to shaping Kenyan jurisprudence, especially in the area of public law. Ndugu, karibu. Welcome, sir.
Asante sana, Bwana Uganda, and thanks to East African Law Society for the invitation. Thanks.
Thank you, sir. Finally, we have Dr. Daniel Ruweza. Dr. Ruweza is a lecturer at Makerere University, the senior lead consultant for the Directorate of Public Prosecutions in Uganda. He's also a practicing advocate, a former consultant for the Citizen Coalition for Electoral Democracy in Uganda, as well as the President Emeritus of the Ugandan Christian Lawyers Fraternity. Miss Dr. Ruweza, karibu.
Asante sana, Mr. Ogada. It's always an honor to be part of these very important discussions. I look forward to listening to the keynote address from the Honorable, the Chief Justice, now retired.
Thank you very much. Thank you very much, Dr. Ruweza. Now, without wasting much time, allow me to humbly and respectfully welcome the Honorable Chief Justice. Please welcome, sir.
Thank you very much, Mr. Ogada, for the introductory remarks, and the President of the East African Law Society for this invitation. Before I start, I normally would like to make a disclaimer that my pronunciations are not the best. I come from, or rather my mother tongue. In my mother tongue, there are some letters which are not there. So if you find me using R instead of L, and some words are not being pronounced properly, you understand where I'm coming from. That said, Mr. President, I'm happy to join you here today as you discuss this important and timely topic on judicial independence in East Africa. Then when you're talking about judicial independence, the first thing one thinks about is what is judicial independence? There's controversy over the correct definition of the concept of judicial independence. Some scholars opine that one needs to consider several aspects of the concept, such as independence from who, independence for whom, and independence from what, to arrive at the proper definition of that concept. The scope of this address does not permit me to go into those conceptions. For purposes of this address, I want to limit myself to the generally accepted definition that judicial independence refers to the ability of courts and the judges to perform their duties free from influence or control by other actors, whether government or private. It is the idea that the judges must be free to exercise their judicial powers without interference from litigants, the state, the media, or any other person. Mr. Chairman, ladies and gentlemen, from the topic of this webinar, independence of the judiciary in East Africa, are a partner states eroding gains made and the emerging challenges, it is clear the objective is to examine the practical challenges to judicial independence in East Africa. As you have correctly observed in the concept note for this webinar, while most countries in the East African region have constitutions that guarantee judicial independence, the unprecedented levels of political interference, budget constraints, and other ills tell a different story, hence the need to dialogue with affected stakeholders with a view to diagnose and manage the impact that the judicial capture has had on the legal profession and what should be done to restore public confidence in the judiciary. In this regard, I will limit myself to threats posed to three aspects of judicial independence, namely the appointment of judges, financial autonomy, and the attacks on the decisional and the institutional independence of the judiciary. On the appointment of judges, it is not in dispute that the appointment and the tenure of judges are among the critical aspects of judicial independence. The history of the judiciary in the East African states bears witness to this. During the colonial period, officers of the executive arm of government carried out judicial functions. District commissioners and district officers doubled up as magistrates with jurisdiction to adjudicate upon disputes. Needless to state that the decisions of those officers, especially in cases of human rights abuses and any other cases, any other insensitive cases, were anything but independent. They mirrored the wishes and objectives of the colonial administration. Though the independence constitutions of most African states embraced the doctrine of separation of powers, however, shortly after independence, the political elite, driven by greed and selfish ambitions, chastened the concept of the concept of constitutional implementation, and they instead embarked on and succeeded in making numerous amendments, the overall objective of which was to consolidate all power, and particularly in the executive arm of government, and in particular the presidency. That led to patrimonialism that did not tolerate any form of opposition. Judges were appointed by, and as it were answerable to the head of the executive arm of government. In Kenya, the judiciary was an appendage of the executive arm of government, subordinated to nothing more than a file in the office of the Attorney General. As we know, the collapse of the Berlin War and the post-Cold War challenges ushered in the third wave of democracy that saw political and constitutional reforms across the developing world. Besides elaborate bills of rights, including socioeconomic rights such as political rights, some of the reforms included the entrenchment of the separation of powers, as well as the establishment of independent judiciaries. Save for Kenya, in the other East African countries, judges are appointed on the advice or upon the recommendation or after consultation with the Judicial Service Commission. And some after that, some have to go through the parliamentary approval. The practice in most of those countries is that the president is given 3 names to choose from for each appointment. This renders the president as the appointing authority. Needless to say that when the president is the appointing authority, the decisional independence of such judges is severely compromised. In Kenya, judges are appointed, and I quote, in accordance with the recommendations of the Judicial Service Commission, end of quote, subject to parliamentary approval for the Chief Justice and the Deputy Chief Justice. The practice is that the Judicial Service Commission submits to the president a list of candidates whose names equals that of the vacant posts of the judges to be appointed. In other words, if the commission is appointing the Chief Justice, they just forward 1 name. The same is the case with the Deputy Chief Justice. If they seek to appoint 10 judges, they simply send 10 names. So in Kenya, the appointing authority is the Judicial Service Commission. That authority is, however, begrudged and has been the subject of serious litigation, some of which is ongoing in the appeal process. In all, the more than 4 cases, the courts have consistently held that the president's role in the appointment of judges is ceremonial, and any refusal to appoint within 14 days all the nominees submitted to him is unconstitutional. And they have also clearly stated that he cannot cherry pick. In this regard, I'm referring to the 41 names that were submitted to the president more than 2 years ago. And recently only 34 were appointed. And you know the litigation that is on that. I don't want to go into any further details. So the whole idea is that in Kenya, and under the constitution, which specifically states that the president has to appoint in accordance with the recommendation of the Judicial Service Commission, the appointing authority is the Judicial Service Commission. Sometimes you see arguments even in the media, unfortunately, of even some lawyers who don't even read the constitution, and they are almost, as it were, misleading the public that what the Judicial Service Commission does is just to recommend, and the person to appoint is the president. With that, now I want to move on to financial autonomy. As stated during the colonial period, the judiciary was firmly under the executive arm of government. Although the independence constitution textually embraced the doctrine of separation of powers and provided for an independent judiciary, that separation was only on paper. The judiciary remained substantively at the beck and call of the executive arm of government. In Kenya, the infamous Kenya prosecutions and many curious court decisions attest to this. It is in this legal history of judicial subservience to the executive that drove Kenyans' clamor for an independent judiciary, both in the letter and in the spirit of the law. It is not in doubt that the financial autonomy is a critical aspect of judicial independence. For it to effectively discharge its mandate, the judiciary requires financial autonomy. The independence of the judiciary is terribly compromised when it is left to the magnanimous discretion of any other arm of government, against which it at times decides cases, as it should be, to provide finances for its operations. I have already, I have in this regard the case of Institute of Social Accountability and another versus the National Assembly. In that case, the High Court declared the Constituency Development Act unconstitutional, and the Parliament was quick to castigate the judge who made that ruling, and threatened to reduce the judiciary budget. And when I talk about this reduction of the judiciary budget, nobody tells you that because of this, the judiciary budget has been reduced. You just see the figures coming down, and when you analyze that, you know what is happening. Regarding after the 2017 nullification of the presidential election, in the financial year 2018-2019, the judiciary's budget was reduced with the development vote slashed from an average of 2.5 billion shillings to a paltry 50 million. Thereafter, the judiciary experienced budget cuts, the worst being in around February of 2020, when the entire ICT vote of about 400 million was taken, when the budget of the other government institutions was reduced by half. It is on the basis of this background that the people of Kenya enacted Article 173 of the Constitution to guarantee the judiciary's financial autonomy and in turn guarantee judicial independence. Clause 1 of that article establishes the Judiciary Fund to which to be administered by the Chief Registrar of the Judiciary. And the clause 4 directs that upon the approval of the estimates of the approval by the National Assembly of the Judiciary budget, the same should be deposited in the Judiciary Fund. Pursuant to clause 5 of Article 173 of the Constitution, which requires Parliament to enact legislation to provide for the regulation of the fund, Parliament enacted the Public Management Act in 2015 and the Judiciary Fund Act in 2016, as well as the Judiciary Fund regulations. Despite this legislative framework, the Judiciary Fund has never been operationalized, and the judiciary remains at the mercy of the executive. Without the operationalization of the Judiciary Fund, the judiciary's financial independence will continue to suffer and portray it as a failed institution. The Kenyans in this audience are well aware of the narrative that the judiciary is the weak link in the fight against corruption. Whereas the judiciary is not perfect and it has its own challenges, the other arms of government want it to remain weak so that it can provide an scapegoat for their failures. I will now move on to the political attacks on the independence of the judiciary. Besides the appointments and the financial autonomy, attacks on judges by the executive and the legislative arms of government also seriously compromise the decisional independence of the judges. In Kenya, judges have ruled against Parliament or the executive in some sensitive cases and have been seriously attacked. I have in this presentation given a number of cases, about five of them, where the courts have ruled against the National Assembly and there have been budget cuts. But I want to mention one in particular. By Statute Law Miscellaneous Amendment Act of 2015, Parliament amended the Judicial Service Commission by inserting a clause requiring the Judicial Service Commission to submit to the President 3 nominees for the appointment of the Chief Justice, from which the President would choose and send the name to Parliament for approval. You remember I mentioned that under the Constitution, the Judicial Service Commission forwards only one name for the appointment of the Chief Justice and the Deputy Chief Justice. When that of course didn't go down well with some people, and they sought this amendment so that they would have 3 names forwarded to the President. The court in the case that was filed by, I believe, the Law Society of Kenya, declared that amendment unconstitutional. Parliament was up in arms, arguing that the judiciary was not adhering to the doctrine of separation of powers and was interfering with its work. I can go on with several other cases with similar attacks, but let me conclude this aspect with the attacks on the Supreme Court by the politicians following the nullification of the 2017 presidential election. Prior to the constitutional reforms ushered in by the third wave of democracy, in Africa, elections did not have any intrinsic value. Instead, they were periodic rituals, which were basically legitimacy codes for leaders who wanted to project facades of democracy, often leading to widespread disenchantment and violent protests. One of the fundamental reforms that we've ushered in was the establishment of independent judiciaries, and the vesting in them with vesting in them with explicit roles for the adjudication of. I'll read that again, and vesting them with roles to adjudicate and determine electoral disputes. Article 140 of the Kenyan Constitution vests the Supreme Court with original and exclusive jurisdiction to resolve presidential disputes, presidential election disputes. Article 187 vests the High Court with jurisdiction to resolve all other electoral disputes. Save for Tanzania, to my knowledge, the other constitutions of the other East African countries have similar provisions. Despite this clear judicialization of politics, if you may call it so, invoking the counter-majoritarian principle and the political question doctrine, politicians often attack courts which rule against them in election petitions. A case in point is that of Eroding versus Uhuru Kenyatta in the 2017 presidential election petition, where the 4 judges of the Supreme Court who annulled the presidential election were viciously attacked and intimidated by the president and the east side of the political divide. You will recall that soon after the Supreme Court delivered its ruling nullifying his election, in a press conference at State House, the president accepted the court's decision and called for peace. However, a few hours later, in the company of several politicians from his political party, he addressed a huge rally in the city and called the 4 judges wakora, a Swahili term for crooks or criminals who had no business overturning the will of the people. Directing his attacks at the head of the judiciary, the president stated, and I quote, "Chief Justice Maraga thinks he can overturn the will of the people. We shall show him in 60 days that the will of the people cannot be overturned by 1 or 2 individuals." He warned, and I quote, "When we finish this by-election, we will revisit this thing. Every time we do things, the judiciary puts an injunction. Who do you think elected you? There is a problem and we must fix it. We must fix it." End of quote. The opposition, National Super Alliance, led by Raila Odinga, who was the petitioner in the electoral dispute, praised the Supreme Court and rebuked the president for threatening the 4 judges. Raila Odinga and his associates boycotted the fresh election held on the 26th of October 2017. After dismissing the second presidential election petition filed by individuals allied to a civil society, it was Raila's turn to attack the Supreme Court. He asserted that the Supreme Court judges were cowards who bowed to intimidation and upheld the President Kenyatta's re-election in the fresh poll. Indeed, with those kind of attacks from politicians, as the saying goes, you are damned if you do, and you are damned if you don't. As he stated above, in his attack, President Kenyatta warned that when we finish this by-election, we shall revisit this thing. Every time we do things, the judiciary puts an injunction. Who do you think you are? Who elected you? We have a problem here and we have got to fix it. This attack is premised on the counter-majoritarian principle and the political question doctrine. As we know, judicialization of politics is the reliance on courts and the judicial means for addressing core moral predicaments, public policy questions, and the political controversies. On that principle, the politicians often argue that as judges are not elected representatives of the people, they have lesser legitimacy than officers of the other arms of government in the determination of political issues. On the political question doctrine, they argue that the courts are prohibited from adjudicating political and policy controversies, which the political branches of government and are better suited and equipped to handle. These arguments are clearly disingenuous. The judiciary did not arrogate to itself the power to determine political and other public policy disputes. In Article 1 of the Kenyan Constitution, the Kenyans have made it clear that all sovereign power belongs to them and that it shall be exercised in accordance with the Constitution. Sub-Article 1, 2 of Article 1 delegates the exercise of that power to the three arms of government, that is the executive, the legislature, and the judiciary. With regard to judicial power, Article 159.1 reiterates that judicial authority is derived from the people and vests and shall be exercised by the courts, tribunals established by the Constitution and any other act. Part of the judicial authority vested in the judiciary is the resolution of political disputes, electoral disputes. As I have stated, Article 140 vests the Supreme Court with the power to resolve presidential disputes, and Article 87 gives that power to the High Court to resolve all other cases. The Constitution, I believe, of the other countries have more or less similar provisions. As Kwasi Prembe observes, this is not a power or authority that the judiciary arrogated to itself. Rather, that people to whom the radical title to state power and authority belongs vested the judicial authority in the courts as a result of the lived realities that to avoid conflict, the legitimacy of the electoral process requires the imprimatur of the courts. He adds that without the express invitation of frustrated or ineffective legislatures, judges would not have inserted themselves in the electoral process, end of quote. The courts have therefore no option but to resolve political disputes. In the electoral process, Article 141 of the Kenyan Constitution states that the president-elect can only be sworn in and assume office after the court has rendered a decision declaring his or her election to be valid if any petition is filed under Article 140 of the Constitution. I believe that there is a similar provision in the Ugandan Constitution. This is a clear recognition that the ultimate determination of the legality and the legitimacy of the electoral process is now vested in the election courts. As such, the election courts must never lose sight of their judicial authority as the ultimate custodians of the Constitution and the electoral justice in particular. This is no mean responsibility. The courts should therefore dismiss the politicians' numerous contentions, questioning their authority to make such decisions in the first place and uphold the will of the people. They must never saddle the people with individuals who the electorates have rejected. As long as they keep to their lane, as long as they confine themselves within the constitutional or statutory authority, the court should dismiss such contentions. I have often stated that even when threatened, the judges of the election courts must never succumb to pressure, intimidation, or any other form of undue influence. Indeed, judges have no business occupying their coveted positions if they cannot withstand such a pressure. The positions of such a judges is not for the timorous or the faint-hearted. In conclusion, ladies and gentlemen, I would like to say that, as already stated, and I've stated that many times, constitutional power is constrained power. In terms of Montesquieu's age-old doctrine of separation of powers, the Constitution limits the powers of each arm of government and those of each institution and the state officers. That, however, some state officers who, as I've said, for selfish gains, desire unfettered discretion to do what they want, including the plunder and looting of public resources. The attempts to determine who is appointed as a judge, the allocation to the judiciary of insufficient budgets and the budget cuts, as well as the attacks on judges, are all meant to interfere with the independence of the judiciary and have the judiciary at the beck and the call of some elites. This webinar, as you have indicated, should come up with ways and means of how that can be effectively resisted and subject everyone to the rule of law. Thank you very much, ladies and gentlemen. I want to wish you all the best in the discussions that you are going to have this afternoon and maybe in the future. Thank you very much.
Thank you very much, Honorable Chief Justice. It's always a joy, it's always a pleasure to hear from you. In addition to the two quotes that I referred to before, please add on to this other one, that the Constitution and constitutional power is constrained power. Without further to make his brief remarks. President Spears, are you with us?
Thank you, moderator, and greetings, fellow panelists and delegates. This is indeed an honor and a privilege to hear this discussion, and it's a great treat to me to hear the Honorable Justice Maraga once again. Some of you may know that he gave the inaugural lecture for the Commonwealth Lawyers Association Africa Hub some weeks ago, and it was pleasurable then to listen to him, and it has been pleasurable today. Thank you for inviting me, and greetings, President Bernard of the East African Law Society. I note from the chat that we have representatives from Paulo here, and we no doubt are connected to other regions within Africa. Can I just mention that the Commonwealth Lawyers Association has a very active Africa Hub under the leadership of Vice President Linda Kasonde in Zambia. Can I also recall with great fondness the time I spent with the Kenya Law Society in Mombasa in 2019, shortly after my inauguration as president of the Commonwealth Lawyers Association. And I have very fond memories of visiting Mombasa and then moving on to Uganda to meet with who is now the president of the Uganda Law Society. So it's a pleasure to be here. It's a pleasure to bring you a greeting from the Commonwealth Lawyers Association. And it's an opportunity to mention that the CLA will have its conference in the Bahamas in early September, we hope, and travel and COVID restrictions permitting. and you are very welcome to consider attending, and you're very welcome to consider joining the CLA and taking part in the Africa Hub. The theme of the conference in the Bahamas is sustainable justice, and it does seem to me to tie in very neatly with this theme of your webinar today. For justice to be sustainable, I suggest it needs to be accessible, affordable, prompt, respected, and supported by law societies, bar associations, and regional associations such as EELS. On the question of being accessible, there are concerns that people might be closed out of accessing courts if the technology is not up to the job and if technology is not available to the litigants or to their representatives. On the other hand, the use of technology makes accessibility much more achievable, and for routine matters, for mentions, for adjournments, for administrative hearings, using technology more seems to be what other Commonwealth regions and jurisdictions are endorsing. For justice to be sustainable, it must be affordable. And that means not only the costs of legal representation, but also the costs of accessing courts. To be sustainable, justice must be prompt. Delays are endemic and have got worse with the pandemic. And there is a backlog in many of the Commonwealth jurisdictions, which is of concern across the board. How do we catch up? Are alternatives to court proceedings going to come more to the fore, such as arbitration and mediation? But certainly delay can create problems for witnesses, can create problems for evidence. And a prompt system is one which is sustainable. And justice to be sustainable needs to be respected, and that resonates precisely with the theme of your webinar today. Because if not respected, then the people do not have regard to it, and it is much more easy for those that wish to criticize the judiciary or the legal profession to have their criticisms gain traction. So respect is earned over time by not only the judiciary, but also the integrity and honesty of court officials and court clerks and administrators. And it is gained by legal practitioners, such as many assembled today, remembering their overriding duty to the court, remembering their professional conduct obligations, and remembering their role as officers of the court. And finally, respect is earned by judges remaining in that space of independence, deciding on the law, not on political considerations, and being fearless, as the Honourable Justice Moraga has just said, to do what is right and in accordance with the law and the evidence, to uphold the rule of law. I am aware of controversies in many jurisdictions, in all jurisdictions across the Commonwealth, and in particular in your region, arising from recent cases, the failure to endorse the Judicial Services Commission recommendation for judicial appointments. And your region is not alone, as I will clarify in some moments when we look far away to Samoa, where the CLA has recently published a statement on the rule of law issues there. And it is of direct relevance to the same issues that the East Africa region will contemplate today. Can I mention from a Commonwealth perspective that there exists the Commonwealth Latimer House Principles. These were adopted by all Commonwealth members in Abuja, Nigeria in 2003. We are all familiar with the principle of the separation of the three branches from Parliament, the Executive, and the Judiciary. And the role of Parliament and the Judiciary are separate and work best when they comply with the Latimer House Principles. Principle 4 of these very important principles, now endorsed and forming part of the Commonwealth Charter and the Commonwealth Fundamental Values. And Principle 4 reads that an independent, impartial, honest and competent judiciary is integral to upholding the rule of law, engendering public confidence and dispensing justice. The function of the judiciary is to interpret and apply national constitutions and legislation. So that seems to me, from a Commonwealth big picture perspective, to be of some assistance to your deliberations today. Can I also mention the UN Basic Principles on the Independence of the Judiciary, long since adopted in the United Nations since 1985. Principle 1 of the UN principles reads, the independence of the judiciary shall be guaranteed by the state and enshrined in the constitution or law of the country. It is the duty of all governmental and other institutions to respect and observe the independence of the judiciary. Principle 4 of these UN principles reads, there shall not be any inappropriate or unwarranted interference with the judicial process, nor shall judicial decisions by the court be subject to revision. Now, these are helpful, and in the guidelines to the Latimer House Principles, they make mention of what Justice Moraga mentioned in his remarks, namely that there needs to be security of tenure, there needs to be an independence of appointment on merit, there must be adequate remuneration and pension arrangements for the judiciary. The court system must be adequately resourced in order that it can command and continue to command the respect of the people. And nothing must be done to compromise judicial independence. Now, it might be helpful just to reflect on the fact that in Samoa, in the South Pacific, following a recent election with an essentially split vote, the incumbent party have refused to accept the result of the election, have refused to acknowledge the swearing in of the newly elected government, and that has resulted in multiple court applications. At one stage, the Attorney General disrespected the Supreme Court of Samoa and said that because, in effect, they were finding in favor of the opposition parties, that somehow their rulings were flawed and they should recuse themselves. Now, although subsequently those remarks were withdrawn, one can see that in another jurisdiction, there is a foment of legal applications, criticism of the judiciary, which undermines the rule of law. And the CLA, at the request of the Law Society of Samoa, yesterday put out a statement calling upon respect for decisions of the judiciary and for the media not to make comments and remarks to undermine the rule of law. So your region is not alone. It is, of course, your region. You live in it, you practice in it, you are concerned by what goes on in it. And the upholding of the independence of the judiciary is underpinned internationally, is underpinned by Commonwealth statements and principles which have been adopted, and it is supported by the magnificent work that your East Africa Law Society is doing in this webinar to highlight the importance of judicial independence, to make it a subject of public discourse, and to have respected figures like Justice Maraga comment in the way that his keynote address did. As a side observation, the rule of law being upheld increases, as many studies have shown, the stability of society, the stability of the economy, the encouragement of inward investment, the encouragement of lending, which can be secured in a secure rule of law-led jurisdiction. And in that context, not only is judicial independence vital for the rule of law, but it is vital for the economy, for the protection of the individual citizen, and for the development of the nation. It is therefore a most important topic, and I look forward to hearing the other contributors, but I hope that these greetings on behalf of the Commonwealth Lawyers Association are of some assistance to your reflections today, and I thank you for the opportunity to bring these thoughts. I will catch up on the recording later for those portions that I missed, as I have another engagement shortly, and I do not want you to think I am disrespecting you by leaving early or disrespecting any of the panelists by leaving early, but it's been really a treat and an honor to bring these thoughts to you today. Thank you for your attention and time.
Thank you very much, President Spears. Thank you for your remarks. We now move to the Q&A session. And before we embark on the quick Q&A session, allow me to give some guidance as we proceed. Before the guidance, I'd like to recognize the presence of Professor Sepemboa. Professor Sepemboa is the chair of the Rule of Law Committee, and the rest of the members of the Rule of Law Committee for the East African Law Society. Welcome, thank you, we acknowledge your presence. Allow me also to recognize the presence of Professor Jill Guy, Director, Katiba Institute. Thank you for attending, Professor. Allow me also to recognize the presence of Florence Jaoko, Dr. Chilanta Pile, Mr. Bobby Mkangi, one of the drafters of the Kenyan Constitution, the Secretary General of PALU, Pan-African Lawyers Union, Donald Dare, thank you, big brother. We also recognize the presence of Professor Abubakar Zain. We recognize the presence of senior advocate from Kenya, Mr. Moses Kurger. Welcome. Now, panelists, in the Q&A session, due to the time constraints and the very heavy interaction in the chat section and the questions that are coming in through, we will humbly and respectfully request you to limit to a maximum of 7 minutes for the presentation, for the preliminary engagement that we will have. For the viewers who are watching, please ask your questions through the chat section, the Q&A section rather. You can also make your comments through the chat section. At the tail end, we hope to have some time to respond to your concerns and your questions. Now for the Q&A section, we will begin with Dr. Edward Hosea. And the first question to you, Dr. Hosea, is this. I hope you can hear me. The question is this,
yes,
Dr.
I can
Hosea.
hear you.
Thank you, sir. The question is this. What is the state of judicial independence in Tanzania? The follow-up question to that is, what can the partner states of the East African community learn from Tanzania? What can Tanzania learn from the partner states? Over to you, Dr. Hosea.
Thank you so much,
Mr. Ogada, can I intervene just before Dr. Hosea answers.
Yes, Chief Justice.
I also have another engagement shortly. So if you see me going out, it is not as a result of any disrespect. I am actually the chair of that other session coming up shortly. So, but I will listen to a few questions before I leave. Thank you very much.
No problem, Chief Justice. Thank you very much, sir.
Thank you.
Thank you so much, Mr. Moderator. Let me go straight to the question. The state of Tanzania independence of the judiciary. Tanzania judiciary has undergone what I would call a reformatory process. The process of independence of Tanzania judiciary is a historical process. And I'll begin by saying that an independent judiciary is necessary for a free society and a constitutional democracy. To ensure the rule of law and the realization of human rights, and also prosperity and the stability of any society, will require the independence of the judiciary. Therefore, the independence of the judiciary in Tanzania is governed under Article 107, capital A, of the Constitution of 1977 as amended. And the Constitution of Tanzania clearly states as follows, and I wish to quote: "The judiciary shall be the authority with the final decision in dispensation of justice in the United Republic of Tanzania. In delivering decisions in matters of civil and criminal matters, in accordance with the laws, the court shall observe the following principles, that is to say, A, impartiality, to all without due regard to one's socio-economic status, not to delay dispensation of justice without reasonable ground, to award reasonable compensation to victims of wrong committed, to promote enhanced dispute resolution among persons involved, to dispense justice without being tied up with the technicalities provision which may obstruct dispensation of justice." Now, to answer directly your question, because I have a few minutes as allotted, I would say that the Tanzania judiciary, to see whether it's independent or not, I would go along the lines that Justice Maraga highlighted in terms of threats. I'll begin with the appointment. The judges of Tanzania are appointed by the president through the Judicial Service Commission, which presents names to the president, and the president picks the names and appoints. So Tanzanian judges are appointed by the president of the United Republic through the Judicial Service Commission. The Judicial Service Commission would send the recommendation to the president, and the president would appoint judges. This is the procedure in Tanzania. It doesn't go to parliament or otherwise. Secondly, in terms of to see whether the Tanzania judiciary is independent, I would highlight that in terms of financial stability, the judiciary in Tanzania derives its finances from the consolidated fund as part of the constitution. However, the judiciary also goes under scrutiny of the parliamentary process, where the parliament receives the proposed budget, and according to the Minister of Finance and the Department of Finance, would always put a ceiling as to how much the judiciary should be given. So I would argue that there is no total independence in terms of resources, because the resources are given by the executive branch of government through the parliamentary process. However, there is a steady improvement over the years in Tanzania in terms of remuneration, in terms of infrastructure the judiciary has been receiving from the government. And therefore, I would say that in terms of finances and the capacity building, the judiciary, to a certain extent, progressively has been receiving that kind of support from the government. Also, the judiciary in Tanzania has entered into digit transformation, and therefore there is a lot of improvement in terms of digital transformation in the judiciary of Tanzania. However, there are other constraints to the independence of the judiciary that the legislature or the parliament has enacted a number of pieces of legislation, so amending the constitution. For example, the Written Laws Miscellaneous Amendment Act of 2020 has amended the Basic Rights and the Duties Enforcement Act, Chapter 3, to limit the judicial review of certain class of persons by adding the contents to the constitution, namely that the application shall not be admitted by the High Court unless it is accompanied by an affidavit stating to the extent to which the contravention of the provision of Article 12 to 29, that is the Bill of Rights of the Constitution, has affected such persons personally. In other words, the constraints that has been imposed to the independence of the judiciary, I would argue, is legislative constraints to limit the ability of the judiciary to freely decide the cases according to the Constitution and according to the laws of the land. So in a nutshell, what I would like to present here, that there is another dimension where the president, apart from being given the list of names to appoint judges from the Judicial Service Commission, he may appoint another person out of that list. And this happened in the previous regime. We call it the fifth government regime, where the president was able to appoint a magistrate by being, the magistrate, perhaps he wrote a good Swahili judgment, and the president was impressed, and he was able to appoint that particular person to become a judge. So there are elements of what I would call political interference to a little extent that we witness, especially in the past regime, that the president was able to appoint not necessarily people on merits or given the list from the Judicial Service Commission, but rather on whom he thought he can become the judge of the High Court. Given the time you have given me, let me stop there. If there is any question, I'll be happy to pick it up from there.
Thank you very much, Dr. Hosea, for keeping within time. We will have subsequent questions for you, but for now, allow us to move to Dr. Deche. Dr. Deche, are you with us?
Yes,
so,
I am.
Deche, the question is this now. We've had the account from Justice Maraga. Now, the question to you is, in addition to what the Chief Justice has said, what could you identify as the structural challenges, or what challenges generally are there with regards to judicial independence from a practitioner's perspective, from a scholar's perspective? Over to you.
Thank you very much, Evans. I think when we are talking about the structure, when it comes to judicial independence, it is one thing where you cannot say that you got it right, you erect the structure, and then you take a walk and think that everything is okay. It calls for vigilance all the time. But having said that, I would say that there is actually nothing wrong with the structure. Maybe what we need to look at is just some bits and pieces that need renovation. And although you say I look at it from a practitioner's point of view, I'll also look at it from the point of view of a former commissioner. And one of the areas which I would call a major area is with regard to the issue of tribunals, the removal of judges, because we know that under our Article 168, the Commission can recommend to the President persons they think need to be interrogated or investigated by tribunals as a result of maybe perceived misconduct. But when I look at that part of the structure nowadays, I am a bit worried because we have seen that the executive now appears to have powers to reward the judges that are perceived to be good to them with a friendly tribunal. And so looking at that, I wonder what can they do to a judge whom they do not like? So that part of removal of judges is a bit worrying, because all the power with regard to the appointment of persons who should be in the tribunal are vested in the executive. And we have seen, Ogada, you are a Kenyan, and you have seen the executive appoint a tribunal that was perceived to be friendly to a particular judge. Now, I leave that at that. The other issue that may not be that major, but it's nonetheless untidy, is with regard to the role of the Attorney General. The Attorney General, let me not use the pronoun he, because it could be she in future, but the role of the Attorney General in the JSC. We have seen that the presence of the Attorney General has become a bit problematic, because the Judicial Service Commission makes decisions which the Attorney General is party to, and thereafter, when the issue moves to court, you find that the Attorney General is now on the other side, now attacking a decision that they were party to. So that part of the architecture where the Attorney General is again both part of the executive, of course, and then part of the judiciary is a bit untidy. And I would think it really needs to be looked into if the independence of the judiciary is to be fastened more. The last part, Evans, is with regard to the membership of the Judicial Service Commission, because those of you who are not Kenyans, I would tell you that the Judicial Service Commission of Kenya is made up of 11 persons, and 6 of them are elected. Now, 2 of the non-elected members are normally appointed by the president, and there's nothing wrong with that. But my concern is with their security of tenure, if I may use that term, because we have seen in the past, they can get recalled anytime. Of course, you hear that they have resigned, but they get recalled. And there was a time when the commission was reduced to 6, and that's the bare minimum of quorum. So we have a situation where it is possible for the executive to cripple the work of the commission through those members. So that is another part of the architecture that needs relooking into. But let me end by saying this. There is nothing wrong with the structure, Evans. The problem is people going around the structure with impunity. But as far as the structure is concerned, it is okay. But as to what we should do to deal with the impunity, I think it's not about disturbing the structure, but looking elsewhere. But of course, we can continue engaging further, Evans. Thanks.
Thank you very much, Commissioner Deche. Always a joy to have you around. Thank you for your good remarks. We will certainly be coming back to you with subsequent questions. Panelists, if you look at your Q&A section, there are questions that have been posed specifically to individual panelists. Please, if you can answer them online, we will gladly appreciate, because we will be working towards saving on time. The next question goes to Dr. Ruweza. Dr. Ruweza, are you with us? Dr. Ruweza, I can see you. Thank you very much, sir. The question to you then is this: what is the state of judicial independence in Uganda? What can the partner states of the East African community learn from Uganda? And what can Uganda learn from the other members of the East African community? Over to you, Dr. Ruweza.
Thank you very much, Mr. Ogada. I'm sorry I had a little bit of internet upset, but I'm glad to be back onto the call. First of all, I think that there are some challenges that our nation is facing, which can be addressed by lessons from the fellow East African states. I believe the trajectory that Kenya has taken is a good one. By and large, the strides that have been made with regard to how judges, and specifically the judges like the Chief Justice, are appointed, are a good step in the right direction, because there's been a limit in how much the executive is able to do. Of course, this came as a result of a new constitutional dispensation that Kenya received. The situation in Uganda, as we all know, is slightly different, because we've had what some may say stable leadership for over 36 years, while others will argue that we have got a president that has not been able to relinquish the seat of power, and it comes with a lot of challenges. For those who may not be familiar with the situation in Uganda, right now, we have had the same president since 1986. And of course, there is a very strong belief, and also evidenced, that the president is quite powerful. And the current constitution, enacted in 1995, with a certain mindset, as seen in our preamble, gave him a lot of powers, which include the power to appoint the Chief Justice and all the judges in the court. Now, of course, that brings a huge challenge, because unlike Kenya, you give the Judicial Service Commission can only recommend, and the president is the one who makes the final appointment. I think the last time we had about 3 candidates that were recommended to the president, and he made his pick. Now, that means that the president does have a lot of power, and everything that Kenya is struggling to retain, Uganda does not have. And that therefore presents us with a huge problem regarding interference, or perceived interference, in the way the judiciary works, or is perceived by others. So a huge knock at the perception of judicial independence, even when you might have individual judges that are well-trained, experienced, but the fact that there is a huge history with most of them with working with the president in other arms of government, that perception still persists, at least amongst either the public or specific circles in the Uganda law society. So what lesson there can we take is that we need to continue engaging with finding ways of ensuring that there is a split between what the president is supposed to do as one arm of the government and what he or she, when one day is able to do later. So that is the biggest challenge that I envisage. Some strides have been made, for which I think some other partner states may be able to pick. For example, the administration of the Judiciary Act that was passed, and I think it's an act in the right direction, because among other things, it has made those strides in giving the judiciary more power to hire its own staff, for example. Before this act, the judiciary could only rely on the public service to be able to receive recommended court clerks and other administrative staff. Right now, the bill or the act promises to give more power, has promised to give, doesn't promise, but does give more power for them at the judiciary to do a little bit more, especially when it comes to hiring, firing, and disciplining their staff. I think this is a step in the right direction, because previously a lot of the perceived corruption was seen to be done by court clerks, and now that there is that power, I think it's a good thing. The payment is better, and we are now seeing more litigants, more lawyers, more experienced lawyers applying to be considered for positions of judge or justice of the Court of Appeal or Supreme Court. Of course, this still has the clincher that the final appointment has to be done by His Excellency, the President. And so one has to be the kind of judge that the President is willing and able to work with. And so that means that you may be qualified, you may be an astute judge or capable to become an astute and great judge. But if the President does not believe in you or does not think that you have the right credentials in his view, then the possibility of you becoming one, either a judge, a justice, or even chief justice is going to be exceedingly impossible. So we may have to find ways of amending the law, negotiating on how the law can be amended to ensure that the judiciary is given more independence in order to appoint judges that it thinks are capable without the necessary interference from the executive. Maybe I should say one more thing, which I think is probably very critical for us. I know that the conversation thus far has concentrated on executive versus the judiciary and related efforts. I would like us to consider, if I may, Mr. Ogada, the question of independence of judges within the judiciary. I think it's a good conversation that we could have regarding how much are judges themselves, how much are judicial officers themselves independent in being able to do and be, in being able to carry out their judicial role without interference from either the fraternity or from those senior to them. I think that is a conversation we could have, but I know that would be diverting from the question you've set. I'll hold my horses for now. Thank you very much.
Thank you very much, Dr. Weza. Is the Chief Justice with us, or he's already left?
He has left.
Oh, okay. We nonetheless thank the Chief Justice for having been with us. We had a couple of questions that we had intended for him to handle for us, but nonetheless, we will find somebody to deal with those questions in due course. Allow me to introduce a very special friend of mine, my elder brother, Mr. Waikwa Onyoike. Waikwa, are you here with us? I can see you, sir.
Yes, sir. Yes, I am.
We have this question for you, sir. The courts in Kenya have made certain decisions touted as formidable statements of judicial independence. And this I have in mind petition E282, the David Ndii decision, the so-called BBI decision, and we have Raila Odinga, the first Raila Odinga decision, the presidential petition. What do these decisions mean for judicial independence analysis? Are they just minor spots in murky waters, or can they be sparks to further the quest for judicial independence? Over to you, sir.
Thanks, Wanoganda. So maybe if I may preface this with 2 or 3 points. First, just understanding the constitutional architecture of Kenya, being a constitutional democracy and what that means in the context of judicial independence. Basically for me, what is important there is that the courts are the custodian of the constitution, and that the courts have the final word when it comes to adjudicating how public power is used. And so to that extent, they're a check to public power. And that even goes to questions relating to the interpretation of the law, as Chief Justice already talked about this, when it comes to who has the mandate or who has what responsibility in terms of selection and appointment of judges. Then remember, under the Kenyan Constitution, and I know it's similar even to other in other constitutions, though the application may be different, is that the High Court has powers to nullify any act or omission done on the basis of constitutional power. So any public power, any act or omission done in exercise of public power. Now going specifically to your question, and it's good that Dr. Weza actually mentioned the decisional independence of judges, because I'll be going there in a moment. I think the issue there, and just for listeners who may not have the full background, there are two cases that the moderators referred to, the 2017 election petition, which Chief Justice talked about, where the Supreme Court nullified the election of Uhuru Kenyatta, and he's running it, the Deputy President, Raila Odinga, and there was a lot of attack. And the second, which is the case that may not have been discussed much today, the David D case, relates to an attempt by a political class to amend the Kenyan Constitution fundamentally through an initiative called the Building Bridges Initiative. And this is critical. First of all, let me just talk about 2017. 2017, the Chief Justice, I think, was elaborate, and the kind of dangers or the kind of abuse the court and the judiciary faced as a result. But what we never emphasize enough is that 2017 decision also showed people the possibility of what an independent judiciary can do, and how much power the Constitution had given to the judiciary in making sure that public power is exercised constitutionally. And it was, in my view, one of those constitution affirming moments, regardless of the insults or the threats that the judges and the judiciary faced as a result. The second opportunity obviously comes with the Building Bridges initiative. And for me, the Building Bridges initiative is even much more special as a constitutional moment in Kenya than even an electoral dispute. Partly or mostly because, unlike in 2017, where the political class was divided by half, and Kenyans by that means, because as many Kenyans who supported Raila Odinga also supported Uhuru Kenyatta. What BBI did was to galvanize the political class, the ruling elite. We have Professor Sesepebwa, and we have Mr. Mkangi here, who are drafters of the Kenyan Constitution. They would tell us and others, I know who are in this forum who participated in making of the Kenyan Constitution, that to a large extent, the Kenyan Constitution is the constitution that the people imposed on the political elite. And the political elite have been looking for an opportunity to overthrow the Constitution. And one of the issues, or one of the areas the political elite has been very, very keen on, is to undermine or to delegitimize the independence of the judiciary. Why then is BBI judgment such a seminal judgment when it comes to judiciary independence? Maybe for two reasons. One that is positive, one that is slightly negative. Let me start with the first. The first is what the Chief Justice and Dr. Weza have already started talking about, decisional independence. I like calling it individual independence of judges. In my view, judicial independence, or the rationale for judicial independence, is primarily one, to create the best environment possible for decisional independence. So the ultimate, or the main beneficiary of judicial independence is a magistrate or a judge. And the reason for that is because what is protected is the decision that the judge has to make sure that it's made fairly and impartially, based only on evidence and recourse to the law. What BBI obviously was the opportunity for the court to be able to show whether they could exercise independence, regardless of the fact that the political or the ruling and political elite had crossed ranks. Raila Odinga has been with Uhuru Kenyatta on BBI. And what the court was able to do is to assert its authority and the authority of the Constitution, and show that it was able to exercise independence. But more importantly, the individual judges obviously showed individual courage. And that's why it's become so unfortunate that the two lead judges in that petition actually are some of the 6 judges who have not been appointed. It's very hard to convince people that the judgment in BBI did not have anything to do with them being appointed. But importantly, and this is now the second point, which is the negative point in terms of BBI and judicial independence, is that it's shown that the president and the ruling elite and political people who have power in formal and informal power in political class can still find ways to manipulate decisional independence of judges, even when we have a very good structure as described by Dr. Deche. And how has that happened? Because it's gone to something the Supreme Court of Kenya in an advisory opinion of in the matter of National Land Commission called perception or independence perception. How it has affected that is by the president being able to assert himself, illegally of course, and choose the judges he wants, specifically leave 2 judges who are the lead judges in the BBI petition, but select other judges and appoint those to the Court of Appeal. It's created the perception that the president still holds significant power and can decide who will be a judge, who will be promoted, who will face reprisal and others. And I hope we are able to overcome that, because at the moment, I think it's extremely unfair, both to the judges who were appointed, in fact, and those who have been left out in terms of the independence perception. The judges who were appointed, there are people who will think they were appointed because they will be doing the bidding for the president, and the ones who are not appointed, of course, for contrary views. And unfortunately, that has significant negative impact on judicial independence in Kenya. Let me leave it at that so that I don't take too much time this round.
Thank you very much, Waikwa. Allow me to recognize the presence of Dr. Sarah Kinyanjui. Dr. Kinyanjui is a lecturer at the University of Nairobi. Karibu Mwalimu. Did I see Jadid Mozad? Yes, welcome, Mwalimu. You are highly welcome to join us. We also recognize the presence of judicial officers who are watching online. We thank you. Please receive the conversation as being stated by these honest contributors. Perhaps that will be profitable to you in your individual stations as you leave the practice of judicial independence. Bobby Mkangi, are you online? And do you have any question or any comments that you'd like to make? Do you have Mr. Mkangi here? Don there?
Yes, sir.
How are you, sir? Mr. Mkangi, welcome, sir. Any comments?
Thank you very much. First of all, I want to, can you hear me properly?
We can, sir.
Okay.
Yes, sir.
Thank you. Thank you for the opportunity. I would like to thank the East Africa Law Society for organizing this very, very timely webinar and all the panelists. I've really enjoyed and been enriched so far from what I've heard. Perhaps one the issue of legislative independence also. The role that the legislature plays. Our brother from Tanzania, Dr. Hosea, did link to this on the aspect of the Tanzanian judiciary being affected or emasculated mainly through legislative action. And here in Kenya, as the Honorable Retired Chief Justice mentioned, the legislature also is sort of a missing link in the whole aspect of the independence of the judiciary. So perhaps as we talk about this, and I know, and especially here in Kenya, we've had numerous questions, some pretending to fatalism that perhaps nothing can be done. We know that there is the alternative of the legislature holding the president to account through impeachment proceedings. But we know because of the political climate, this may not come to fruition. So I think as we look at this entire issue, there is the doctrine that has been thrown about in the interdependence of the arms of the state. And this sort of, and especially here, being touted to be more explicit, of which it is implicit, but to be more being thrown to the fore than the explicit separation of powers and independence of the judiciary. So perhaps the membership and the audience and the panelists could also look at these issues, and especially how the legislature or the legislative arm of state plays a role in determining the independence of the judiciary. Thank you.
Thank you very much, Mr. Mkangi. Mr. Mkangi was one of the drafters of the Kenyan Constitution. We truly honor your contribution and sacrifice. Thank you, sir. There are a couple of questions on the chat before we go to the second round of questions. now that the Chief Justice has exited, perhaps the question is this, Dr. Deche, what is the way forward given the constitutional impasse created by the failure to gazette and swear in the 6 judges? This is a question from Castro Shirima. Dr. Deche, what is the way forward?
I'll repeat what I've said before. The ball is squarely in the court of the executive. That's the appointing authority. And like I said before, I reiterate that the process has no reverse gear. So the ball is there. It cannot go back to the Judicial Service Commission. The president must do the right thing, and that is to appoint. So maybe we'll be talking about, in default, what if he doesn't? What do we do? But the ball is fairly on his court. Should I only answer that or the others in Q&A?
We will look for one more other question, but for now, thank you very much for that response. We have another question. I don't know if David can help me, but I see another one. This one can perhaps be answered, but the question is this: is it possible, with the differences in systems, is it possible to have a merged East African justice system? Dr. Rueza?
Oh, thank you very much. You mentioned David, and so I thought there was someone else. Is it possible to have a merged East African justice system? Why not? Why not? We are more united than you think, or than we think. If you look at the history of most of our peoples, really, there are some comments I would have made here about some people being Ugandan, and though they belong to certain countries and they are doing well there, they are more Ugandan than you think, and so we just smile quietly and know things are going well. But that's a conversation for another day. Yes, we can have a joint East African justice system. You remember, these are all porous borders, first of all. These are superficial borders. Our people interact much more than we think. And the conception of justice that is African is not only within the East African region, but it is in all of Africa. And therefore, I strongly believe that it would be a step in the right direction to begin such conversations that help address some of the things that have become endemic to our countries, individual countries, and yet they could be addressed if we opened up the possibilities of working together. As you know, at some point in time, we had the same university, we had the same airline, at some point we had relatives who were leading in different countries. And therefore, I think that the concept of justice, African justice, Ubuntu, and so on, are concepts that you find all over our peoples. And I think it would be good for us to start these conversations, which will also mean having judges and justices who think beyond their small, that small enclave of saying, no, this is my territory or this is my other territory. I like what Kenya is doing, for example, and I think it is something we could borrow. My understanding is that Kenya has got different courts of appeal that are in the different regions of Kenya. Uganda only has one court of appeal, constitutional court. I'm told there is a constitutional court in Mombasa. There's one in Nairobi, and And I think this gives you an idea that it is possible for us, therefore, to borrow some of those concepts, work out our political or perceived political differences, and maybe the judiciary would be one of those places where we are always normally agreeable on what the law should be, or what the purpose of the law should be, what the rule of law is about, and yeah, take it on from there. Thank you very much.
Thank you very much, Dr. Weza. Thank you very much. Ever the optimist, Dr. Weza believes that it is possible to have a joint justice system. I saw somebody raise his hand. Anybody with questions to voice? We had Dr. Kilasanatha Pile. Dr. Pile, are you with us? You had a question to pose. Dr. Pile?
Evans, as Dr. Pile comes in, I just wanted to remind our listeners that at the time of granting independence, you remember the colonial masters had planned that it would be independence to the whole East African region. And you know, many of our laws are applicable. You know, some of our listeners who may be students have always talked about Rex versus Amkeo. It may be good for them to realize that Rex versus Amkeo is not even a Ugandan decision. It's a Kenyan decision, which we've seen quite a lot in our first year class. So there is more together than without. Thank you.
Thank you very much, sir. Is Dr. Pile with us? Down there? Down there? Anybody with a question? We have Neil Samuel. Neil Samuel, are you here? Neil Samuel? Anyway, as we're ready for these questions, perhaps we can take a second round of questions. Those who want to air their questions viva voce, please, Samuel can't unmute. What's happening? Samuel, are you with us? Just a second, let me see if we can.
I am with us now.
You're with us, thank you. Can you voice your question and tell us who you want to answer the question?
Okay, thank you for the opportunity. My name is Neil Samuel. I am a student of law in Nairobi. So my question, I would have loved it if the former Chief Justice would have answered it, but anyone from the Kenyan branch can answer. We have seen how in the Kenyan context, we have a legal framework to cater for the independence of the judiciary, that is under the provisions of Article 160, and then financially under the provisions of the Judiciary Fund, which, as we have seen, it has not been implemented to date. So when you look at this, and with the constant attempts, especially by the executive, to ignore the orders of the court, to try and usurp the functions of the court, to try and control how the judiciary works, is there any hope for judicial independence? Because the legal provisions are in existence, but they don't really seem to be functioning. So what can be done to deal with this situation? Thank you.
Waikwa, Neil talked of the Kenyan branch. I still believe we can own you as Kenyans. What is the way forward? We have the institutions, we have the law, but judicial independence is not working. What is the way forward? What can we do?
So I actually think judicial independence in Kenya is working, and the constitution has been working. Of course, it's not been working at the maximalist levels that most of us would want to see. But by and large, the constitution has served well as well, and judiciary especially has served us very, very well. The reason the political class is extremely frustrated is because they realize that judges are willing, a lot of judges are willing to exercise their decisional independence. To some extent, the Judicial Service Commission, although at times it can be very, very disappointing there because people tend to align based on political interest, sometimes even what some of us suspect to be ethnic interest. But still, we've seen the Judicial Service Commission come out in numerous times to defend the judges, individual judges who have been attacked, but also to assert the independence, the need for the independence of the independence of the judiciary. And we are also lucky that two of our retired Chief Justices have been very, very vocal and positively so when it comes to judicial independence. One thing politicians, I'm sure, would want to tell everyone is that the people are with them and the people are not with the judiciary. That's not my read, actually. And to the extent that the judiciary is able to keep educating people, and some of us who are in positions of privilege, and I think a lot of us in this webinar are, to the extent possible, we keep countering narratives by the executive, narratives by politicians about usurpation of power by the judiciary. And we are able to show why the judiciary is doing the right thing, the better. And in fact, the greatest beneficiaries will be the people. I feel, and this is not just in Kenya, it applies to our region, regardless of how judges are appointed and all that. We never pay sufficient tribute to our judges and magistrates, the amount of workload, the amount of responsibility they carry, and how they discharge that. If for nothing else, I think citizens ought to support them. But yes, I hear this frustration in Samuel's voice, and it's the frustration I have. I wish things could move faster, but I keep hoping that we keep getting judges who are willing to push back regardless of the fear of reprisal. Thank you.
Frustration, pent up. I'm equally frustrated. This leads me to the next question. Dr. Deche, but before we come to Dr. Deche, please, allow me to engage. We have a question for you, Dr. Deche, from the chat. There are actually two. Before we come to you, allow us to engage Dr. Hosea. Dr. Hosea, if you're still with us. Mheshimiwa Rais?
Yes, I'm around, sir.
Thank you very much, sir.
Yes, I'm around.
Kuna swali hapa.
Okay.
What will you say to politicians? You've interacted with them in your sphere of work with anti-corruption. What will you say to them are the advantages or the benefits of judicial independence across board?
I would tell the politicians that in order for the politicians to have legitimacy, they have to understand the role of the independent judiciary and the rule of law. It is through the independence of the judiciary and the rule of law that makes their existence legitimate. For example, in our region, the laws can be improved if the politicians, they understand the concept or the doctrine of separation of powers. The doctrine of separation of powers is not alien. However, we need to make sure they understand that for them to be good governors, to be good presidents, to be good managers, they have to respect the independence of the judiciary, because that's the bedrock of democracy in the context of the rule of law. Therefore, if politicians, they appreciate that disputes are properly resolved through the judicial process, then their job will be easier to govern, because disputes will continually be resolved by the judiciary. In Tanzania, for example, the regional commissioners in your country, perhaps you call them governors, they enter this realm of resolving disputes through the media. And I thought they could do a better job than trying to resolve the disputes if they understand the limits or the limitation of their powers. So I urge politicians in East Africa to respect the Constitution, to respect the rule of law, to understand that the separation of powers is an important component in democratic dispensation in our region. Thank you.
Sagely advised from Dr. Hosea, respect the rule of law, respect separation of powers. It builds confidence. Thank you very much, Dr. Hosea. I now come to you, Dr. Deche. Waikwa spoke seems not to be what we expect. The question is this: what or how
Please repeat, Evans. I think there was some freezing at some point. I don't know.
You lost me.
End.
Okay. Can you hear me now?
Yes, I can.
The question is this now. Owing to the frustration about the reality of judicial independence, how can individual judicial officers ensure popular respect for and faith in the court system so as to nurture judicial independence? What can individual officers do?
Okay, thank you very much. But before I go to the individual officers, let me just mention something that to encourage Neil. Neil is the one who was feeling frustrated, and Waikwa joined in the frustration. So that I say that we have come a long way as Kenyans. I can see people even in the chat talking about how far ahead Kenyan is. But I can say that we are all riding on the backs of people who had to pay the ultimate price. Some died, others were detained. So we have come a long, long way. And also to let Neil know that judicial independence is something that we have to fight for. And it's something we have to preserve. You cannot say, there, I got it, and then walk away. You have to stay vigilant. And I always think we will never talk, we hardly talk about independence of parliament, probably because parliamentarians are loud enough to talk for themselves. We never talk about independence of the executive, but we have to talk about the independence of the judiciary, because it is the one that is under threat. And it's when people like you and I talk that we take care of that. Now to the question of individual judges. I think it behoves each judge and magistrate to live up to their calling, up to the calling of their office, by being mindful of those values that are there in the, I think the Bangalore principles, they are there in our constitution. And we are talking about values like integrity, we are talking about propriety, and at all times, we are talking about decisional independence. So maintaining those values and integrity shows, integrity speaks for itself. And when you live up to the calling of your office, you will not even need to defend yourself. People will defend you. Remember, judicial authority and all authority is vested in the people. And Waikwa has said that people are with the judiciary, or the judiciary has the people. So when you are upright in your ways, somehow people will be able to defend you. And let me say this propriety, this integrity should not only be in the course of your work, it should also be away from your office, so that the way you manage, whether it's alcohol or whatever other thing that you imbibe, you manage it responsibly. If you have children, whether in wedlock, outside wedlock, under wedlock, above wedlock, wherever children you have, you manage them properly so that you have that sense of propriety. And that will go a long way into having allies, because judicial independence is a war or a fight that can only be fought properly with proper allies. I always think that it is best and it's more effective when other people talk in your corner, talk from your corner, other than the judges themselves, because the judges talk through their decisions, so they cannot again be found outside there defending themselves. And let me end by saying this. We have, or judges should be mindful, and let me not appear to be lecturing them, but it's important for them to be mindful of drawing the boundary or the line between independence, decisional independence, and incompetence. Because Kenyans know, they may not have gone to law school, but they know when you are blundering, when you are exhibiting some incompetence, and when you are exercising your judicial decisional independence. Thanks, Evans.
Thank you very much, Commissioner. There was a question posed by Dr. Sarah Kinyanjui. I don't know if she's still online. Dr. Kinyanjui? Dr. Kinyanjui? We have Brian Moshiri. Moshiri, there's a question you wanted to pose to Waikwa. Is Brian Moshiri with us?
He has put the question on the chat. Okay, he's here.
Yes, Brian.
Yes, my question was, where do we separate judicial excesses or activism from independence of, or vis-a-vis the separation of powers? Where do we draw the line? That is my question, if I'm audible.
Yes, you are. Thank you.
Yes. I've had the question. So first of all, I think it's important for people to understand how language gets appropriated and used negatively to undermine causes of reform. So, for example, activism has been given a negative connotation. And so when people talk about judicial activism, they tend to be communicating that judges are doing something that is not allowed under the law. Just as I've seen in recent past discussion about judicialization of politics, and again, from a very negative connotation. So just as a starting point, the question becomes, what is being referred to as judicial activism? So and the second point is activism, especially in societies that are transforming, is a positive attribute and one that should be encouraged, as long as the activism is geared toward achieving transformation. And if you look at the 1995 Ugandan Constitution, and then you look at the 2010 Kenyan Constitution, those constitutions were prepared with an eye to transformation. And the judiciary in both constitutions were given extremely extensive roles in helping the different countries achieve transformation. So whether it's on socioeconomic rights, and I know there's variation in terms of the justiciability issues on socioeconomic rights between the different countries. But for example, using the Kenyan example, on socioeconomic rights, fully justiciable under the Kenyan Constitution, and the judges are actually expected to take a significant role in deciding whether the government is, for example, undertaking its mandate in terms of resource rationalization and sometimes even allocation to achieve the intent of the Constitution. So I would be very careful using judicial activism, or at least propelling that notion from a negative connotation. Having said that, obviously there is always possibility that activism can go either way, and there are judges who will overreach themselves, as we have seen the executive always overreaching itself. We've seen Parliament always overreaching itself. But then we also have an accountability mechanism. And as Commissioner Deche said, in the Kenyan context, for example, while it's there are still a bit of problems because those who are charged with implementation sometimes manipulate the process. The Constitution provides a very useful accountability mechanism so that if a judge is doing this activism through overreach that cannot be justified under the Constitution, including the looking at the leeway, the very, very wide berth that judges have been given in terms of interpretation of the Constitution. So, for example, under Article 259 or under Article 20 on rights and even doing whatever they have to do to give effect to rights where they're not fully recognized or fully facilitated, then there is an accountability mechanism. But by and large, I would say that it's the Constitution in Kenya especially that requires the activism we've seen in judges. In fact, judges who are not taking the activist role that the Constitution requires them, they're the ones shortchanging the people and undermining the Constitution. Thank you.
Thank you very much, Waikwa. Mutitasira, this is a Ugandan name, difficult. This is the question directed to Dr. Uweza. Dr. Uweza, the question is this: what do we do to rectify judicial independence issues in Uganda? This is a question from Jasfat Mutitasira. What do we do to rectify issues of judicial independence?
Thank you very much. Judicial independence, of course, has to be tackled from a holistic perspective. Like I started the conversation earlier, they are both inward and extra challenges that need to be addressed. Let me first start with us as the East African Law Society or the Uganda Law Society in concert with her sisters and brothers in the East African region. There are conversations like these ones that need to be able to continue and to engage with the leadership of the executive arms in our various countries. Before COVID, we used to have the hosting of these conferences, and there was always the preference to invite the leadership of the executive, that is the presidents, to come and listen to these conversations. So that is the first level of engagement. But secondly, the reason for having court action is that you can be able to make certain changes using the courts. My brother Waikwa has just been talking about judicial activism. And the idea of judicial activism is really to breathe life into the law. Where there are challenges that are taking place, where there is a clear mess, where it is impossible to do much, then you seek the intervention of the courts to try and rectify what is clearly not working. And I guess the challenge now is on the sitting justices and judges to be able to make certain inroads in assisting either the executive or the legislative arms of government by making decisions that are seen as progressive enough to begin speaking about those aspects of judicial independence that are really going wrong. For example, how are people being selected to sit for interviews before the Judicial Service Commission? Is the process, is it procedurally right? Is the public being involved? Is there information that is picked from those who know about some of the candidates, the way Kenya is doing it? Or are we sitting back? But thirdly, there may be situations where more drastic actions may have to be taken. I remember Uganda had what we called the Black Mamba saga, or the rape of the courts of judicature, whereby some members perceived to be of the opposition arm of government were granted bail, and then there was a takeover of the courts with men in black, security officers surrounding the courts and so on and so forth. I remember Her Lordship, Justice Letitia Mukasa-Kikonyogo at that time, who was Deputy Chief Justice, asked all members of the judiciary to put their tools down until a serious conversation was had with the head of state. I think that was a statement that had to be made. So depending on what actions have been taken that are impinging on the independence of the judiciary, I think we have we need to all be part of these conversations. The parliament and the progressive members of parliament asking relevant questions, or asking the public for questions, and maybe creating a forum like is happening in Kenya, where when people apply for these positions, and some people have got certain concerns about your integrity and so on, this can be brought to the fore. We, the academic lawyers, or those who are seen as just being academic lawyers, we also have a role to play in proposing what we think can help improve on the independence of the judiciary. I know that Uganda has at least taken the first step of a law that is being seen as going in the right direction. But now we need to have harder conversations, especially where the East African Law Society brings to fore the bar bench conversations now at an East African level, where we have frank conversations, where we think that certain members of the judiciary are not doing what is right, or where we think that the executive is clearly undermining decisions. For example, there's been a tendency in Uganda today to ignore decisions of the judiciary. A court makes a decision, makes an order, and the order is ignored by an officer. And life goes on, as in, should a judicial officer continue functioning normally when their decision has been totally ignored, or should they stick with the idea of I am functus official? I think there comes a time when some hard conversations need to be made. When the Attorney General is summoned, I liked what we did in 2016 with the structural interdict, where we asked the Supreme Court, and the Supreme Court actually agreed not only to pass a decision regarding the elections, but to make recommendations. But this time the recommendations should be fulfilled, or there should be tangible steps made. Unfortunately, when the Attorney General was brought before the courts of law, before the Supreme Court once again by Professor Sempewa and Professor Juko, the court probably shied away from finding the Attorney General in contempt and gave the Attorney General more leverage. I saw Professor Sempewa here. He could say one or two things about that case. But I think those are unique opportunities that courts have to put their foot down and say, we've given you specific orders, we gave you adequate time of 2 years to do them, and you have not done so. And so we are going to find you in contempt, regardless of who the office bearer is at that time. And I think those hard decisions help give faith to people and to the judicial officers. But lastly, I would really want maybe the East African Law Society at another time to have these conversations regarding the independence of judicial officers themselves, within the judiciary. And I know my brother Wanyoike Waikwa had said something about that. To what extent are judicial officers independent to write a decision? If it is, for example, a panel, if it's a panel and you have a dissenting opinion, what happens there? Are you convinced to decide in a certain way or not? The experiences from the judiciary would be worth interrogating. I think I am informed that when it comes to, for example, a criminal case at the appellate level, there must be consensus of the whole bench. But what if a judicial officer feels that they disagree with them, with the majority opinion? Maybe borrowing a leaf from the International Criminal Court and the international tribunals could help encourage the judicial officers to go ahead and have dissenting opinions, even in cases like the criminal cases where ideally there should be consensus as to whether someone is guilty or not. So those conversations, I think, can continue, and hopefully that and a few other additions that members might have could help. Lastly, the person who asked me the question is a student. And I'd like to suggest that students have a role to write in the papers. They have a role to engage. They have a role to do research, support their lecturers in research, to volunteer in law firms, and interrogate these issues as well, because we all must act together, because the very person asking the question is probably going to become a judicial officer one of these days. And whatever he or she can do right now to make it possible for them to have their job well done is critical. But Mr. Ogada, we should not forget that our judiciary comes from the society in which we live in. And therefore, we might have to call upon other members of the media and others to start asking hard questions and to start making certain interrogations regarding why certain decisions are made the way they are done, investigating on behalf of the Judicial Service Commissions, and helping the public, and not necessarily applying in just sensationalist news. Not that that is what they do, but it's good for them to help us, because at the end of the day, the judicial officer, if independently provided for, if he or she feels independent, if he or she is well facilitated, if he or she is assured of the promotions that will come from complying with the way the work demands, and making sure that there are no privileged positions for some judicial officers over the others, I think those will all be good steps in the right direction. Thank you very much.
Thank you very much. We have around 6 minutes remaining. I'll ask us to maximize on time. Let's keep it very short. I have 2 more questions that we need to respond to. There's a hand up. I see 3 now, but allow me to take the first hand up. Otieno Alwoka, please pose your question. Keep it quite short if you're here. Otieno? Otieno, please unmute yourself. If Otieno is not ready, do we have Boniface? Okay, since they're not ready, there's a question that has been posed to Dr. Deche on the chat. Who is this, Boniface?
Yes.
Please keep your question short.
Yes, I've been following the conversation. Then I'm getting surprised as to whether the East African Court of Justice is so much independent to that extent.
Okay. Thank you very much. Independence of the East African Court of Justice. As we think about that question, There's a question posed to Dr. Deche. Dr. Deche, the question is, you raised concerns about the role of the AG, the Attorney General, in the Judicial Service Commission. The question is, what happens to the Law Society when it sues the Judicial Service Commission? Over to you, Dr. Deche.
Thank you very much, Evans. I'll keep it short and brief. And I raised it within the context of structural deficiencies. I was making proposals of what can make the structure better. And to me, those two roles are not comparable. You cannot compare the role of the AG or the presence of the AG in the commission with that one of the LSK representatives. And my concern are twofold. Number one, if you look at the peer commissions, by the peer commissions, I mean the commissions that have to do with the other two arms of government. That's the Parliamentary Service Commission and the Public Service Commission. The AG does not sit there. So the question is, and I may sound rude or bad by asking it, what is he doing in the JSC, Judicial Service Commission? Is it, to me, it's a kind of executive guardianship extended. So I think that needs to be looked at. And before that, it used to make sense for the AG to be there because the JSC used to be more or less a department in the Office of the Attorney General. But after 2010, now we even have the representatives of LSK there. I believe the AG used to be there as a titular head of the bar, but now we have actual representatives from the bar. And I think then his role in the current Judicial Service Commission needs to be interrogated. Then secondly, the question of the untidiness that therefore comes up when the AG is party to a decision made by the Judicial Service Commission, especially those decisions that are made consensus decisions. When they go up there to the executive, then the executive is not happy with them. They end up in court. The Attorney General has to shift now from the side of the Judicial Service Commission to the side of the executive. And in fact, most of the times, the AG is the one that sues or gets sued. So, and I can think of two cases, you know, about the Warsame appointment case where the AG was on the other side of a fellow commissioner. And then we have this current case of appointment of the judges where the AG was party to the decision that ended up with the recommendation of those names to the executive, but now he has to jump onto the other side. So that is the extent to which I was saying that we need to interrogate that whole arrangement. It's kind of not working. Thank you.
Thank you very much. We have less than a minute to go. Thank you. We don't have time to make concluding remarks. On behalf of the President of the East African Law Society, on behalf of the Secretariat headed by the Secretary General David Mongosi, on behalf of the panelists, Chief Justice Maraga, Dr. Deche, Waiko Wanyoike, Dr. Rukweza, Dr. Hosea from Tanzania, thank you very much. We appreciate the conversation about judicial independence is a long conversation. It shall continue. Please look out for the next series of webinars. The rule of law, constitutionalism remains our conversation and we'll continue having them. Thank you very much. God bless you. Keep safe. See you the next time. Thank you very much.